Welcome to the Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment one, we'll be discussing the prosecution of local law enforcement officers in both Franklin and Athens County, and the indictment of a 13-year-old charge of rape after the accused allegedly messaged his accuser on Facebook. In segment two, as promised, we'll be exploring the motor vehicle exception to the Fourth Amendment's warrant requirements. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube. Look to the law office of brianjones.com and all of our social media outlets for everything you need to know about your civil rights and the criminal injustice system. So, Erica, did you see in the news this week that 3 Columbus police officers have been cited and pled not guilty to alleged misconduct during the protests in the summer of 2020?
Yes, I did. And I was wondering how that was going to play out because sometimes when there's just like almost seems like a brawl like situation, it's really hard to figure out who's doing what. And, there's a lot of different accounts because, as they say, if you look at a car accident, you ask 10 people what happened, they'll all have a different story. So I was wondering how this would turn out. Can you tell us what are the officers accused of doing exactly?
Investigations have been ongoing since the protests in the summer of last year, but the police misconduct during those protests has now resulted in charges for these 3 officers. Now remember that those protests were motivated by the murder of George Floyd, and both the FBI, a special prosecutor, and other law enforcement agencies have issued these misdemeanor charges against these 3 officers. So one officer is named Holly Canode, and Holly is charged with 1 count of falsification and 1 count of dereliction of duty. Her accusations arise from a video of her fabricating a reason to arrest a protester. So there was no valid reason for her to arrest the protester, but she falsified a reason and arrested the protester without probable cause. Now, Officer Tracy Shaw is accused of 3 counts of assault, 3 counts of dereliction of duty, and 3 counts of interfering with civil rights. Her accusations stem from the pepper spraying of peaceful civilians. So you may recall videos of law enforcement just walking along the protest route, pepper spraying people. And in Tracy's case, she was pepper spraying reporters, validly credentialed members of the media. Officer Philip Walls is charged with 2 counts of assault and 2 counts of dereliction of duty and 2 counts of interfering with civil rights, also for pepper spraying peaceful civilians. So these charges, these accusations, for the most part, stem from abuse of peaceful protesters. And it seems, based on the information that we know right now, that all of these accusations are supported by video evidence.
Well, they must have had to sort through a lot of video to get to these conclusions. And that brings me to another question, because there's a lot of media there's a lot of people with cell phones. You and I have spoken about this before. When you see something, you can get your phone out, you can videotape it. Try not to intervene when there's officers involved and they're trying to do their job, but you're absolutely allowed to videotape it. How does the media attention affect the defense strategy of these cases?
Erica, we've handled a variety of cases that have had media attention, all the way from low-level interpersonal contact on Facebook and Facebook posts, messenger posts, all the way up to national media attention. And it's critical for the defense strategy to incorporate a media strategy into the defense. Media will affect jurors. It will affect the judge. It will affect the prosecutor. The attorneys have to be prepared to be on stage. The defendants have to be prepared to be on stage from the moment they walk into the courthouse to the moment that they leave the courthouse. There's going to be video audio, there's going to be reporters writing notes constantly throughout this process. It's important to investigate and follow up on social media commentary. It's important to investigate threats and harassment. We've had a variety of clients who have suffered harassment and threats online and really pushed back hard against that, because that's not appropriate. It's not appropriate to dox these individuals. It's not appropriate to to threaten them or harass them online. Um, and then I think in order to try and corral and control the narrative, it is to reach out to the press and give interviews, engage in press releases. It's important to protect these clients who have their lives plastered all over the front page and all over the internet, to protect them from the collateral consequences of these stories going viral.
And I know we've talked about collateral consequences. Wow, say that 5 times fast. Collateral consequences in the past. And, it really does affect their lives if they are convicted, or even the media around it while the case is going on. They can lose their family, they can lose their jobs, um, for the foreseeable future, even with their career. I mean, it's a really rough situation, and it's good to have a defense attorney that understands how to handle the media and how to really handle what could be just treacherous collateral consequences. Will these officers be able to continue in their positions?
Their continued employment with the Columbus Police Department is a matter completely separate and apart from the criminal process that is now moving forward. There are, honestly, there are dozens of officers employed in the Columbus Police Department, and certainly hundreds, if not thousands, of officers across the nation that have criminal records that still get to be police officers despite their criminal records. So the disciplinary process, the process of removing them from this position, is separate and apart from the criminal process. Now, in the criminal process, the officers are entitled to a presumption of innocence. The proof in order to remove that presumption of innocence is proof beyond a reasonable doubt. But in the disciplinary process, the standard, beyond a reasonable doubt, is much lower. And they frequently lose their right to remain silent in that disciplinary process. Note that in this particular case, while we are a year removed, sometimes, and I think in some of these cases, more than a year removed from the actual actions, no formal administrative process has started. So these officers have enjoyed the ability to remain silent for this entire year. They haven't been hauled into an administrative proceeding where they have to defend their badge by speaking out and making statements that can ultimately be used against them in the criminal proceeding. Now, that's because these officers are protected by a powerful union, and they have chosen, through negotiations, through back channel pressure, to not move forward with the administrative process. Now, there are a variety of alternative options to termination as well. So if this administrative process doesn't go in their favor, then the CPD can impose additional training. They can give them performance improvement plans. They can suspend these officers. They can demote these officers. So termination is not a foregone conclusion for these officers. Can they continue in their position? Yes. Will they? That remains to be seen.
Well, that is interesting, and I hope that you will update us on the situation as it unfolds.
We will absolutely continue to monitor the story of these three officers and keep everybody updated as the story continues. Now, another officer in Ohio who has been under investigation, indictment, has now pled guilty as part of a plea deal that requires him to testify against family members. Did you see this story out of Athens?
Yeah, and I found it a little bit confusing. I'm glad that you're here to walk us through this because it sounds like the guy got caught doing something and then tried to cover it up, but then said he was, I don't know. It's just it seems very convoluted. What was the deputy accused of doing exactly?
The accusations stem from allegations against family members of Deputy Jimmy Childs. Now, Deputy Childs was involved in an investigation of his family, and those family members were accused of a variety of sex crimes and covering up those sex crimes. Deputy Childs gained access to a recorded phone call wherein one of the suspects in the sexual abuse case made incriminating statements. Officer Childs deleted the recording of that phone call and then lied to investigators about deleting the phone call. He was indicted for a felony 3 tampering with evidence and obstruction of justice charges, but ultimately pled guilty to disorderly conduct. What a fantastic plea deal he got worked out. Now, in exchange for that plea deal, he's also agreed to forfeit his Ohio Police Officers Training Academy certificates and agreed to testify to the contents of that recorded call against his family members.
So he erased the call, but now he's going to use it as part of his testimony. It seems like that is impossible. So if the deputy has agreed to testify about the recorded call, would that be called hearsay? Is that even admitted at trial?
You're correct that anytime a witness is saying what he said or he heard from another person, that is that is fundamentally hearsay. But there are a variety of exceptions and types of statements that actually aren't hearsay. And one of those exceptions, one of those statements that's not actually hearsay, is an admission by another party in the case. So what the theory is that you are not going to go around telling people that you have committed crimes. And if you do go around telling people that you've committed crimes, you're going to be truthful about that, because why would you lie about committing crimes? Why would you lie about confessing to a crime? So, and notwithstanding the fact that we all know that people falsely confess all the time, this is admissible evidence. So Deputy Childs, or I guess former Deputy Childs, will be able to testify as to the content of that call because it is a statement by a party opponent. Now, this is why we often see things like police interrogation videos played with the prosecution, and the defense doesn't object to it on hearsay grounds, although there are a variety of other challenges that can be made to that kind of evidence. So this is actually not hearsay. This falls under one of the variety of statements that are considered not hearsay because of what we consider indicators of reliability, which is, again, why would somebody claim that they had committed a crime that they didn't actually commit?
No, it's true. It would be very strange if somebody did that. So I can see how that's working. So how does it affect a defense strategy of the family still facing charges?
So this is a really interesting situation and pretty unique, where the person who's testifying against the family isn't a co-defendant in the traditional sense, but rather an accomplice who's accused of aiding and assisting them in avoiding detection, albeit according to uh, Mr. Childs, unintentionally. The cross-examination, I would just salivate at the opportunity to go after this guy. We're going to attack him on his dishonesty in procuring the recording, his dishonesty in deleting the recording, his dishonesty in lying to his superiors about what he did with the recording. And now, because he's all buddy buddy with the prosecution, and he's got all these huge favors. I mean, let's be honest, Erica, a felony 3 can send you to prison on a first offense. There are plenty of people who are sitting in the Ohio Department of Corrections right now on a first offense felony 3 charge. And he gets it knocked down to a disorderly conduct in exchange for his cooperation. That's amazing. So we're going to attack him on that issue and all the reasons that he has to fabricate the content of that recording. And the fact that the audio recording is gone and the accused has no way of verifying the content of the statements is really troubling. And so I think that it opens that piece of evidence up to a variety of attacks pre-trial. Um, Legal attacks to exclude that evidence entirely. And wouldn't that be ironic if Mr. Childs were to get this sweet, sweet plea deal, and then in the primary case, that evidence were excluded by the judge? Taken in another light, Child's credibility is absolutely demolished by his behavior, by his criminal convictions, and it's really going to affect whether the jury believes his version of the contents of the call.
Wow, what an interesting case. And I mean, he'd be lucky to have you, Brian, because I know you've got some fantastic strategies, and you'd be able to knock those down with some of the ones that you just talked about. It is definitely interesting, and another example of an uneven playing field with him getting all of those plea bargains, um, as opposed to just the regular Joe who wouldn't get those normally. So I'm glad that we're talking about this and bringing this injustice to light.
You absolutely cannot imagine a non-law enforcement person getting this sweet of a deal. It just doesn't happen. So, obviously there's some insider dealing here. Obviously they're giving benefits to their friends. But we'll see how that works out in the end, and if it damages the prosecution's case. Digging into the background of this case, the primary case, the case of alleged sexual abuse. If those charges of sexual abuse are true, they're pretty heinous. I mean, we're talking about years long sexual abuse of a family member by a variety of the members of the family, and then the cover up of that sexual abuse for several years. So, if they're able to exploit this Mr. Child's behavior, we'll see what happens with that case. Another one that we're going to continue to follow up on and see what the ultimate outcome is. Last but not least this week, Erica, did you see the story of the Facebook message that has led to an arrest warrant on a 2013 Pennsylvania college case of an alleged sexual assault?
Wow, what a stunning case this is. You just said in a message, I raped you. I mean, we've talked about this type of situation before where, it's the internet. It's hard to prove this kind of thing. I can't wait to hear what your thoughts are. Now, how did the accuser and the accused come to be discussing the alleged rape by Facebook message?
The story right now is that the accused sent the accuser multiple messages on Facebook and engaged in conversation. During that conversation, the accused allegedly said, "I raped you. I'm sorry. I'll never do it again." Now, back in 2013, the investigation was closed and the law enforcement declined to file charges. But after receiving these messages, they have reopened that case and are considered, they have issued a warrant. So they are issuing charges, or they have issued charges against this accused person. Now, cell phone evidence allegedly connects the accused to the IP address that the messages came from. And while the accused has not yet been located, the the fact that he is overseas raises questions on several fronts.
It is so interesting. But I'm surprised that a Facebook message could be used as a confession. How is that possible?
So the statements are not hearsay because they are statements by a party opponent. It falls into that non-hearsay definition. So the defendant in a criminal case, any statements of the defendant in a criminal case that are inculpatory, statements that make you look guilty, can be used against you. This is why you don't talk to the police, because when you tell the police, I didn't do it, I am innocent, and here is all the evidence that supports my innocence, none of that evidence is admissible unless you get on the stand and say it yourself. Every inculpatory statement that you make, every little slip up, every admission can be admitted into evidence without cross-examination, without context, and used in whatever way the prosecution wants. So this is the reason you don't talk to police until you've talked to a lawyer. But in this case, the statements are going to be used by the prosecution to prove a REAP conviction. And in order to do that, they're going to have to prove that the device that the messages were issued from was in the possession of the accused, was in his possession at the time the messages were sent, that he himself sent the messages, and that he made those statements with the intent of them being truthful statements. Now, we've defended several cases where the state hung its hat on a confession only to have the jury find our client not guilty. In this Me Too era, a statement like this could be nothing more than an apology. I understand how you feel about this, and I apologize. But that doesn't mean that he is admitting to committing a crime. He may say, I'm sorry that you felt uncomfortable in this situation. I'm sorry that you have experienced this mental trauma over the last several years. So it's going to be really interesting how the defense counters these allegations.
Is there a way to salvage this at all? I mean, what's the best way to defend against damaging admissions? I mean, I understand he probably felt guilty after years of thinking about it. I just don't know how you can come back from this.
Well, it's layers. It's layers, Erica. So the first layer is trying to exclude the evidence on constitutional grounds. Is there a constitutional violation of the accused rights here? From the surface, the little bit of information we know, I don't know that that's present, but absolutely in every case, we want to explore that. Then we try and exclude it on a rules basis through what's called a motion in limine. We're asking the court to say, based on the rules of evidence, this isn't admissible because it's not reliable. How was it acquired? Is it authentic? Can we challenge the way that it was collected? Can we challenge that it is in fact our client's statement? Then we look to factual based ways to deal with this statement. So we're looking at the context. Was this a controlled call? Is this a text message? How is the entirety of the conversation occurring? What's the context in which these statements were made? Can we say, this is a situation where the accused had some ulterior motive for making these statements, trying to get back into her life. Maybe he's, like you said, maybe he's just feeling guilty about an uncomfortable encounter and wants to apologize because he feels like it's the right thing to do. The accused himself is going to need to get a mental health evaluation, and we're going to need to look to whether there was some undue influence, whether there's some cognitive deficiency that has caused a confusion of messaging or a susceptibility to doing this sort of thing, making these sort of false statements. The effective use of pretrial motions, both on a constitutional and a rules basis, and then investigation of the context, can be used both to eliminate the statements entirely from a trial or use the state, limit the harmful effects of the statement, or use those statements as favorable evidence in the defense at trial.
I can see where those strategies would work.
With that, Erica, let's move on to our featured segment today. As promised, the Fourth Amendment to the United States Constitution provides protection from warrantless searches and seizures. We learned that last week, but there are exceptions to the rule. One of the oldest and broadest exceptions is known as the automobile exception to the warrant requirement. Today, let's talk about the automobile exception to the warrant requirement.
I find this particular topic very interesting because I think I told you that I had a boyfriend in college who ended up getting arrested and on the 5 o'clock news for trying to be a vigilante or dreaming about it. And the way he got caught was that someone thought that he looked suspicious, him just parked in his car, and they came by and looked in the back seat, and they saw like the end of a crossbow sticking out or something of a duffel bag. And he ended up getting arrested, but later on got off on a technicality because they didn't have the right warrant. But that was 20 years ago now.
Thousands of Americans have experienced. You're in your car, and all of a sudden the police are knocking on your window and they're pulling you out of your car, and now they're ripping your car apart, trying to find evidence of a crime. And this dates back to 1925 in the state of Carroll versus the United States. That case occurred during the era of Prohibition, and officers had arranged a controlled purchase of liquor from a man named George Carroll. The transaction was never completed, but the liquor control agents, wanting to get their bust, chase him down and pull his vehicle over, search it, and find liquor in his car. Now, the motor vehicle exception was created by the Supreme Court to allow that evidence into trial, and it gives permission to officers in that case and cases moving forward to search a car or motor vehicle without a warrant, so long as they have probable cause. So it's kind of a backwards looking warrant request, right? So they still have to have probable cause to believe that evidence or contraband is in the vehicle. It's kind of like a little bit of Monday morning quarterbacking of a search. We're going to say, because there's a lower expectation of privacy on a car, and we have that lower expectation of privacy in a car because there's a variety of regulations that determine how they operate, what their functionality is, where they can go, how they're supposed to be operated. And there's an exigency, right? There's the ability to move the car away from the police, put it in a secret location, remove all of the criminal contraband from it and hide it. So we're going to say, so the Supreme Court said, well, these cars are heavily regulated and you can move the car and hide the evidence. So police, you can go ahead and search it. You've got to justify your search on the back end, but go ahead and search it.
Are there exceptions to the exception?
There are exceptions to the exception, and the key here is the expectation of privacy. So for example, the automobile exception doesn't include vehicles that are parked on private property where there's a reasonable expectation of privacy. So for instance, a car that's in your garage gets all the protections of your house. Even a car that's parked in your driveway gets a certain higher degree of expectation of privacy, a certain degree of additional protections, because it's what we call it's in the curtilage of the house. What's the curtilage? Well, the curtilage is your house and all the stuff around it. So the police can't just go around searching the stuff around your house because it's close enough to your home that we as a society, as a legal concept, want to protect that from unreasonable searches, right? The other exception is a parked mobile home, like an RV. California versus Carney kind of carved out that section. So, and then last but not least, Erica, remember that the search ultimately has to be supported by probable cause. So a reasonable belief that there's evidence of a crime in a certain location and that there is objective evidence to support that belief.
That is so interesting. So, and I have an RV, so now I know I've got a backup excuse if I ever decide to do something criminal. I'm just kidding. I'm not planning on it, but if I do get in trouble, I know who I'm calling. Um, so how is the legal concept of possession relevant to the motor vehicle exception?
So this is a key concept, and what we're most frequently talking about when we're talking about the motor vehicle exception is possession of drugs. Remember that George Carroll's case was possession of liquor back when liquor was an illegal drug, and so we're most frequently talking about possession of drugs. Often we're also talking about possession of weapons, but these are the two big evidence items that come into play when we're talking about the automobile exception. And the Supreme Court established that ownership of objects in a vehicle is absolutely irrelevant to the legitimacy of the search. So if your bag is in my car, you can't assert an expectation of privacy on my behalf. So that's my bag now. And anything in it is my responsibility, especially as it comes to the Fourth Amendment. Now, when we get into a trial situation and actual proof of ownership, there's a different standard there. But for exercising your constitutional rights over that bag, it's my job to assert those rights, not yours.
That is really interesting. And you do have to be careful. I mean, it's especially with the question of just letting people get in your car that might have drugs on them. I mean, you hear about people using that excuse. Hey, I didn't know he had that. I was just driving the car. I think there was even an example in something about Mary where, where Ben Stiller's character gets arrested because of the guy, um, having murder weapons or something in the car. But I mean, maybe you remember that scene. Um, how does the motor vehicle exception affect the average person in their daily life?
The exception has been expanded to basically all forms of vehicles. So it's been expanded to motor homes, it's been expanded to trucks and the trailers that are pulled by trucks. It's been expanded to boats that are being pulled by cars, and it's even been extended to airplanes. So it's the mobile object exception at this point. And you're right, Erica. Drivers must be aware of who they let into their cars, because anything that that person brings in with them can be charged against you. So you really have to be cautious about who you permit in your motor vehicle and what they bring into your motor vehicle, because you're going to be the responsible person because it's your vehicle. And even if it's not your vehicle on the title, it's your vehicle if you're driving it. So if you're the driver, be careful who you let in your car. And most importantly, we have a phrase here around the office when we're discussing cases, when we're strategizing cases, we call it rolling PC. So don't be rolling PC. Drive the speed limit. Use your turn signal. Be properly registered. Have insurance. Obey traffic devices. Always consider everything that's going on around you and control what you can control, because there are a variety of factors that you can't control. And when you come to the attention of the police, you are going to lose all control of your situation.
Oh, that's sage advice. And if people follow that advice, I'm sure that there'll be a lot less people arrested for crimes that they didn't commit, or things that they had nothing to do with. They just happened to have someone in the car that maybe didn't have the best intentions on what they were doing with the rest of their day. But they don't need to
Absolutely.
drag you into it.
Right. Yeah, that's absolutely the case. Erica, thank you so much for engaging this discussion with me. And everybody who's out there listening, thank you for listening to our show this week. To keep informed about the most interesting stories in the criminal injustice system, holding the police and the government accountable for their misdeeds, and all the exceptions to the Fourth Amendment's warrant requirement that you need to know about to stay safe out there, check out the law office of brianjones.com, facebook.com/Central Ohio Criminal Defense, and at TLOBJ on TikTok, Twitter, and Instagram. We'll be back next week with a sui generis episode and perspective on the next big thing in civil rights and criminal injustice system news, as well as a discussion of the exclusionary rule and how we keep evidence out of a trial based on the Fourth Amendment. Now, Erica, my grandfather always told me when we parted ways, hey, kid, don't do anything I wouldn't do. And to that, when I part ways with my friends, I add, if you do and you get caught, call me. I'll defend your rights as I would want mine defended.